It's wonderful to be here and to celebrate Professor David Bilchitz's new book. And we also have a wonderful panel of speakers today. And we do have one quick apology to start off with, first from Professor Benita Mayersfield, who was going to join us, but had to pull out fairly last minute because of COVID-related travel issues, which we're all very familiar with in this new world. But Bonnie has sent through some comments and we'll find ways to bring those in later. So my name is Selwyn. I'm a New Zealander, hence the accent, and a student here at Oxford. I help to facilitate the Oxford Business and Human Rights Network, which puts on events like this. So if you want to find out more details, those will be in the chat. This event is also brought to you by the Oxford Bonavero Institute of Human Rights, and also the South African Institute for Advanced Constitutional Public Human Rights and International Law, of which David is the director. Again, there are more details in the chat. So the structure today is straightforward. We'll first hear from David himself, who, as we all know, has extensive expertise in the field of business and human rights. And this new book is a wonderful new contribution to the field. We'll then turn over to our two panelists today. So first, Professor Stephen Gardbaum from UCLA School of Law, where he is the faculty director of the Promise Institute for Human Rights. So welcome, Stephen. And second, Professor Danwood Chua. Welcome, Danwood. Recently appointed Dean of the University of Cape Town and Chair of the Board of Trustees of the UN Voluntary Trust Fund on Contemporary Forms of Slavery. I could say much more about all three of them, and their bios are on the event page. But yeah, what I want to say now was to stress a big thank you from David and myself for your time and contributions. But I'm sure we're all keen to launch into things. So David, I'll hand over to you to do your presentation. Thank you.
Great. Thank you very much, Selwyn, for the introduction, and greetings to all the participants in this webinar. I would like to start by thanking the Bonavero Institute for hosting and for the really helpful and engaged arrangement of this event, from Selwyn himself, from Lisa, who's behind the scenes here, Mechleen and Eleanor. Really many thanks, and also to Professor Cato Regan, the head of the Institute as well. Much appreciated for your support on this, as well as the staff at the South African Institute for Advanced Constitutional Public Human Rights and International Law, which is a center of the University of Johannesburg, and particularly Naomi Ho, who was working on this specifically. A book, of course, involves so many people involved in providing support and a range of various elements. And I've, in my preface, outlined my thank you, so I'm not going to spend a long time saying thank yous. The book is really the product of many, many years of reflection on business and human rights from about 2008, and then perhaps more solid work from the time of my sabbatical in 2017, focusing on this question of the substantive obligations of businesses in relation to fundamental rights. So without further ado, I'm going to ask Lisa's going to put up the PowerPoint. So we're going to take you through some of the arguments in the book, and we've decided to focus on chapters 6 to 8 of the book, and I'll explain to you why as we progress, why that's going to be the focus. And then thereafter, we're going to have looking forward to the comments of the two wonderful commentators, and also from those who are joining. You're welcome to ask questions, and I look forward to the engagement between us. So those of you who would like to get about the next slide, actually is just a discount flyer, and I think they're going to, Bonavero is going to put in the chat. There is an opportunity if you want to get the book to get a discount, so you can actually just use the code, and then that will allow you to get that discount. So let's go on to the next slide then. And the focus, as I said, really the focus of fundamental rights discourse has been on the obligations of the state in respect of the individual. Non-state actors such as corporations have the power significantly to affect these rights. And that's been really recognized since the start and the dawn of engagements with fundamental rights. And I go back to some of the early thinkers involved in that. And so what I do here is I focus on a particular non-state actor, the corporation. And the first question that arises is, do corporations have obligations flowing from such rights? And there has been quite a bit of ink spilt about that question. And so I move on actually to focus on the second question, which in a sense presupposes the first. But if they do have such obligations, how do we determine the substantive content of those obligations? And a lot less ink has been spilled, particularly in the legal field, on that question. And this is where I'm seeking to make my contribution. Now, to see why that question matters, I'm going to start with two examples which will relate to many people that will recognize these. The next slide, please, Lisa. The first relates to question of free speech, right, and a civil right, right? Increasingly, corporations are worried about the use of social media and how the conduct of employees and how that affects them, and whether or not they can regulate what employees say. Consider an example of a corporation here. I'm using a fictional one, but actually it's based on real life examples, DataNet, which includes a provision in a contract with directors that they may not post personal opinions on their personal accounts. So we're not talking about accounts of the company itself, on their Twitter or their Facebook or their Instagram or whatever is going to be used without prior approval of the board. Okay. Now, clearly, that is an example of something that has serious implications for the free speech rights of directors, right? At the same time, the company says if the directors express, for example, a negative view, they do business with Russia and they speak out against a potential invasion again of Ukraine, that may affect their business interests in Russia. And therefore, they justify that interference with free speech in order to conduct their business. Okay, and so this raises a question of the negative obligations of corporations. Okay, with negative obligations refer to what you must not do, right? How to avoid harming rights. Okay, so what obligations do they have not to harm the free speech rights of employees? And is such a restriction on the behavior of a director permissible? Even if you sign it in contract, perhaps if you violate a constitutional right, that may not be permissible. Okay, so that's the first set of questions, and we'll see that distinction between negative and positive is going to be quite important. The second example relates to positive obligations, and I use in the book, I actually start the book with the case of a poor individual, Thandi in South Africa, who's diagnosed with breast cancer. And a drug known as Herceptin, which is produced by the pharmaceutical manufacturer Roche, is incredibly effective in treating breast cancer that expresses the HER-2 gene. Okay, in 2017, the drug retailed at $40,000 a year, right? Really, really expensive drug. And that high cost means that it's not available either in the public system, right, or in private health insurance to Thandi. Okay, Thandi cannot get access to this drug, and she literally, if she doesn't, she may well die from breast cancer. Okay, and there are similar issues we know today around COVID-19 vaccinations. Okay, and access to COVID-19 vaccinations, which has largely been in the hands of the global north, and actually many poorer countries have been unable to afford the most effective vaccines, which have been the mRNA vaccines, okay, and have often been charged at a horrific price to poorer countries. And that raises the question of positive obligations of corporations. Do corporations have obligations actively to ensure the medicines they develop and manufacture are accessible to all who need them? And that also, when we deal with positive obligations, it's not just about what we mustn't do, it's about what we must do. And there are many things that could be done, right? So must they provide the drug for free? Or must they price the drug differently for poorer countries and wealthier countries? Okay, must they engage and create a distributional network for the drug, for example? Okay, must they share their recipe of mRNA vaccines relating to COVID-19? These are all the kinds of questions that arise in relation to positive obligations. Okay, and so I hope these two examples already show you how relevant and important that question is. And so the goal ultimately is to develop a legal analytical framework for determining the substantive content of corporate obligations with respect to fundamental rights. Okay, what am I going to do in this presentation? I'm going to go over a structure of the argument. Okay, so give you an outline. The book actually follows together in a I think a coherent structure, I hope. And then I'm going to look into some key arguments from chapters 6 to 8, which outlines the approach I adopt or develop built on the existing case law, what's called the multi-factorial approach to determine corporate obligations. So let's continue. A starting point is in the nature of the corporate agent itself, right? If we're going to be talking about corporations, we have to understand corporations, right? And so we need to go into the nature and purpose of the entity itself, okay? And I focus on two issues. There are a lot of issues that can be discussed here, but is the relationship between corporations and the individuals underlying the corporation, right? Which is a crucial issue because, again, there's going to be a difference between the rights we recognize of individuals and the rights or the obligations of corporations themselves as the corporate entity. And I develop what I call a supervenience model. And this means ultimately that the legal corporation is not reducible to the individuals underlying it, but remains dependent upon those individuals. Okay, there's some elements I'm going to just sketch tonight because it's not possible to go into the detail of the argument. Okay, so I'm just giving you the outlines of what I claim. The purpose of the corporation then is important to look at, and I defend what I call a socio-liberal conception of the corporation. And that, in fact, makes my life a little bit harder, as we'll hear a little bit later. Okay, because if I decided to adopt one of two extremes, it might make my life easier. But I think I'm aiming here in the book to actually capture what I think is a reasonable and true view of the corporation itself. And that means it has a complex character. On the one hand, I contend that its raison d'etre is to achieve a range of social benefits. Okay, the corporation itself is not something that exists in the natural world. It actually is a construction of law. And as such, as a construction of law, it can only be constructed actually legitimately if it has a social benefit. And even traditionally, the capitalist arguments around corporations tend to argue that there are social benefits from its creation because the very separate legal personality, for example, confers what's called limited liability on individuals who invest in it, and therefore they're willing to take more risks, for example, and that produces a range of social benefits in innovations, etc. Okay, so the corporation has a goal of social benefits, but on the other hand, it's designed to, in a sense, accomplish that through individual behavior, individuals seeking to achieve their economic goals through a structure that is advantageous to them. Okay, so it's a complex structure here which has a social benefit goal, but it does that through taking and utilizing individual self-seeking economic behavior. Okay, and that key dual dimension is going to be important in providing a persuasive view of corporate obligations. Okay, next slide. And so then the first part of the book, which we aren't going to focus on in this webinar, right, examines a series of legal doctrinal responses adopted both internationally and in domestic courts to address the potential impacts corporations have on fundamental rights. And here I seek to use what might be referred to as an inductive approach, understand and draw out how courts have thus far engaged with corporate obligations, right? And I identify 4 types of models, right? And some of them don't actually recognize corporations have direct obligations in relation to fundamental rights, okay? But there's what I call the state duty to protect model, the indirect application model, the expanding the state model, and the direct obligations model. Okay, I'm not going to go into that in any detail here. You can read how I capture those models and the various critiques of the various models in the book itself. Okay, the next slide, please. And through this discussion, I I essentially come up with two important recognitions. In each of the approaches, a number of which, as I say, deny corporations have direct obligations, I essentially find that courts do, in fact, have to engage with the task of determining those obligations, right? So they deny they have to do it in some cases, but they actually are doing it, okay? And unlike most of the discussions which focus upon horizontality and verticality and indirect horizontality, I actually try and go beyond that, actually. So I analyze some of the cases which are quite famous, but I go further to look at the reasoning processes which the court uses to reach conclusions about fundamental rights obligations. And I argue that that analysis uncovers an interesting convergence in the approach utilized by courts to determine the substantive content of corporate obligations. Okay, and so there's actually a convergence. Of course, it's not perfect, but there's a convergence on a kind of approach. And the second part of the book attempts to justify, systematize, and develop the contours of this, what I call an emergent multifactorial approach. Okay, so let's go to the second part of the book then. Next slide, which outlines the multifactorial approach. It's really the heart of the approach towards substantive obligations. So firstly, what is a multifactorial approach? Well, it's an approach whereby there's no single criterion on the basis of which to reach a legal conclusion. In other words, there's no one normative considerational factor that alone determines the obligations of corporations. In other words, we cannot simply say that if X factor is present, then Y obligation flows, okay? Instead, determining the substantive content of the obligation is the function of multiple considerations, okay? Now, this won't necessarily come as a surprise to many legal theorists here. This links up with ideas of principles that are in the writings of Dworkin and Alexei. And essentially, we can say that there are several principles at play in determining corporate obligations. Courts then identify features of a situation that are relevant to specifying an obligation, where none are determinative, and then they utilize a decision procedure, such as balancing, to arrive at a conclusion. Such a multifactorial approach can, of course, result over time in particular rules that are related to the context. And it becomes therefore known in a legal system, for instance, that where there is a particular constellation of factors, particular obligations flow. Okay, next slide. Now, why would you have a multifactorial approach? I mean, it might seem much easier and better if we could just specify one factor and arrive at a conclusion. That would be nice, right? I wish that was possible. However, the part of the reason is that there is normative complexity. No one reason can alone justifiably determine the legal position in the context surrounding obligations or remedies where other reasons operate too. Consider that example of the effect on the fundamental rights of directors I gave you at the beginning, relating to their free speech, okay, versus the autonomy and ability of the corporation to achieve its goals of achieving its business goals, okay? So there's complexity there. There are different considerations, and you can't just use one, okay, to make a decision. Second issue is incrementalism. We're actually at an early stage of development of thinking around corporate obligations, and the multifactorial approach allows the development to take place in an incremental way. Another argument is what would we call context sensitivity. The factors have differing relevance in different contexts, and in a way, it's pretty suitable for corporations, because when I talk about the corporation, I talk about an entity, but actually corporations differ in a wide range of manners, right? Their size differs, their functions differs, their business activities differ. So actually it allows one to calibrate one's conclusions relating to the nature of the corporation. And finally, there's a question of judgment, right? And this is going to be important here, that actually the multifactorial approach requires judgment on the part of those utilizing it. And in some ways, that's a positive. We'll see there's also a downside, but it can avoid simply box ticking and require that people actually think through carefully what the implications of fundamental rights are in the context of the corporation. Okay, next slide. Now, there are, of course, some very bad weaknesses of a multifactorial approach, which is also mentioned in much literature around socioeconomic rights and proportionality. Okay, the approach obviously isn't clear. You can't say if X, then Y. The factors can pull in different directions and it leads to lots of discretion. There's an argument that it can weaken fundamental rights. It's not clear what individuals can claim and allows wide-ranging justifications for abrogating rights. And that can be particularly acute for corporations where there are pressures of profit, and that will tend to displace interest in fundamental rights. And corporate capture. It allows corporations who are primary decision makers to determine obligations and often place disproportionate emphasis on commercial interests vis-a-vis fundamental rights. Okay, and that can also impact later on how reviewing authorities such as courts consider substantive content as well, particularly if they give deference to the corporate decision. So what are we to do in the face of these drawbacks? Next slide, please. Well, I argue we can't simply invent the idea that there's an ability to say if X, then Y. Simply bright line rules are neither possible nor desirable in these domains. And that's true of fundamental rights generally, as well as determining corporate obligations in the sphere. However, one must try and respond to some of the critiques and strengthen the reasoning process. And that's part of the goal of my book. And that involves 5 main elements, okay, which I outline in the next slide. Firstly, we need to be able to identify the relevant factors in advance. And I don't suggest there's a closed list here, but we can at least have a sense of what's generally relevant. We need to then understand the normative grounding of the factors and how they condition obligations. And doing that allows us to develop presumptive principles of what will be the case in the situation. So, for example, the larger the capacity of a corporate entity to harm a right, the more extensive will be its obligations to avoid harming that right, and the weight attached to the need for it to avoid negative impacts. Okay. The third step is there's a need to develop a clear reasoning process for balancing where the factors pull in different directions, and that allows arriving at final obligations. Given the ineliminability of judgment, and this is the last part of the book, which I'll mention briefly at the end, I actually found we needed to attend to who makes the decisions and their accountability. Okay, and that requires us to consider the institutional and legal reforms necessary to improve decision-making, considering corporate obligations. Okay, and lastly, ultimately, there will be the emergence of rules. Over time, rules governing an area, I've already mentioned that, or cluster of cases around social media, around pharmaceuticals, will become more firmly established and clearer. And so those flexible factors and principles will translate into rules. And we already have some rules that govern this area. Okay, next slide. Now, how does the multifactorial approach work? Well, I'm starting off with negative obligations because they are slightly different the way we treat them. In relation to obligations not to harm rights, I suggest there are 2 sets of factors. One set is I call beneficiary orientated factors, and those are focused on the rights holder. We need to firstly identify the interest affected underlying the right and its urgency. And urgency is determined by how it relates to the most serious dimensions of individual lives. The second issue is what we might call vulnerability, and that involves understanding the relationship between the rights holder and the agent and their susceptibilities to the exercise of the agent or the corporation's power. That recognizes power relations and relationships, and it really is drawn from the wonderful and fascinating jurisprudence of the Colombian Constitutional Court, which has, again, one of the most advanced discussions in this area. And lastly, the impact on interests. Okay, and that focus ultimately on the effect on interests in concrete situations, having due regard to the degree of harm, the nature of the agent, and the relationship between the beneficiary and the agent. That ultimately requires us to understand contextually what's the impact. Okay, next slide. The second set of factors are what I refer to as agent relative factors, and that concerns the agent who must perform the obligations. Here we need to firstly understand the capacity of the agent, and that's a flip side of vulnerability, but it focuses on the power of the agent to affect interests. And importantly here, not every capacity to impact negatively is impermissible, okay? Capacity is not sufficient, and that's a real problem in some international instruments and others, okay, where it translates very quickly the notion of impact into impermissible impact. There's a distinction, and that's quite key. Okay. Function relates to the public-private nature of the entity. That's how it's often understood in a sense in lay terms, although I reject that binary in many ways, and I really focus on the features of the entities in concern. And this requires thinking about the general function of corporations, and we've already talked briefly about that, about their social and individual dimensions, as well as their specific functions in particular areas, which grants them specific rights. So the media has specific functions in a democracy, for example, and also has a specific ability due to its function to affect, for someone's reputation, for instance. And lastly, autonomy. And this is the one that often pulls in different directions, tending to reduce the obligations of the corporation. This is about the freedom to be able to realize the purposes of the corporation. Now, autonomy has stronger weight in relation to individuals, but it has some weight in relation to corporations, okay? And it's important here to understand the facets of autonomy that are affected in particular situations, not to overstate them. And they often relate to the ability to conduct economic activity, the social functions of the corporation, and perhaps property rights as well. Okay, next slide. Now, as I said to you, some of these factors pull in different directions. The capacity of the corporation may support imposing onerous obligations, and autonomy weaken the obligation. And given the factors pull in different directions, a decision procedure is necessary. How do we reach a final conclusion about the obligations of corporations? And so chapter 7 argues that in the context of negative obligations, we can use the proportionality inquiry to do that. Okay, and the first part of the chapter argues why a notion used in the context of state obligations is applicable to corporations, because it's not obvious why something that applies in the state context can apply to corporations. Okay, next slide. And I argue here, I won't go into this in too much detail, but that proportionality is a general structure of reasoning for dealing with areas where normative conflicts arise. It can also enhance, and this is quite an important argument, I contend, it can enhance a culture of justification that should be applied not only to the state, but also to non-state actors. I imagine a director requiring an employee to count thousands of pages for no reason, and then to repeat the counting over and over again, right? It's almost like torture, but someone may not have the power to leave their employment given the weak conditions of employment in many countries around the world, okay? And so that would require a justification ultimately for the exercise of power consistent with human dignity. In this case, that would be treatment which is not consistent with dignity. And lastly, I argue proportionality applies where there's asymmetric power between the state and the individual, building a presumption in favor of rights, okay? So given the state is asymmetrically situated in relation to individuals, I also argue that the same applies in relation to corporations and individuals. And the amount of power will vary, but the very act of incorporation increases the power of the corporation vis-a-vis individuals. This is one of the arguments I make. Okay. And the second part of the chapter focuses on the mechanics of applying the test to corporations. I cannot really deal with this for time reasons, but we will hopefully raise it perhaps in questions and for further discussion. Okay, the next slide, please. Now, what about positive obligations? This is often more controversial. Many people accept, well, corporations cannot harm rights, but do they have to do anything positively, actively to help realize rights? And there's a worry that this will interfere strongly with the autonomy of individuals and corporations. Okay, and so there's been a model developed that says, well, corporations have negative obligations, but they don't really have positive obligations to assist or to contribute towards the realization of rights. And the first part of this chapter really is an attempt to challenge those arguments and argue that actually corporations do in fact have positive obligations. And then I move on to considering how do we determine their content. And similarly, there's a similar structure, beneficiary-orientated factors, agent-relative factors, and similar factors apply, except, and next slide here, there's an additional important set of factors here in relation to positive obligations. And that is because positive obligations require there to be active steps taken to realize rights. And that can be done by multiple actors. Think about realizing a right to healthcare, or realizing ensuring people have access to COVID-19 vaccinations. It's not like Pfizer alone can ensure that happens. There are multiple actors who have to be involved. So the content question here is, how does the existence of multiple actors, that includes the state and other companies, affect the obligations of each? And actually, one of the general arguments about positive obligations is that they're going to go way beyond the capacity of private corporations to realize. But once you recognize that there are many actors involved, that helps to some extent reduce the force of that charge, because it's possible to distribute the obligations across multiple actors. And there's also an issue of coordination. You also don't want the duplication of efforts, right? You don't want Moderna and Pfizer both to supply the full amount of vaccines for a country and therefore waste a large number of vaccines. And an example that's given in some of the literature is in Nigeria, where 2 parallel roads were built, where there was a need for roads to be built in different places, but because there was competition between different actors, they built roads in the same, essentially in the same space. Okay, so that obviously is a bad use of resources and not in a proper realization of obligations. Okay, the next slide. Now, how do we determine what the final positive obligations are of corporations? Well, I argue that actually proportionality does not work well in this context due to the fact that we're dealing with an omission. For example, it's very hard to determine what the purpose is of the omission, right? There may not be a purpose. And if there is, it's really quite difficult to determine. And that really affects the whole inquiry, the whole proportionality inquiry. So I actually propose a 7-step test, right? And I'm really interested in reactions to this test as well, which I think is quite a practical way of reaching conclusions about final obligations of corporations. The first is to determine the impact on a person, on an individual, on the rights of individuals that are imperiled by the lack of action. The second is to identify the positive actions that are required. Then to look into the state capacity and whether the state is capable of addressing the need and if the corporations affect that capacity. Then to look at the specific functions of corporations, for instance, Pfizer and Moderna in the context of COVID-19 vaccinations, or Roche in the case of Herceptin. They have very specific abilities to help. If there's no specific ability, we can look at general obligations flowing from the social benefits corporations can provide. And last 2 steps, we need to evaluate the various alternative courses of action and their impact on the corporations and the rights of beneficiaries. This is kind of parallel to the necessity test in proportionality. And finally, we need to evaluate the justifiability of the course of action given the benefits to the beneficiaries and the costs to the corporations, right? Given this is quite complex, next slide, I suggest that we should actually use a simplified model. This is actually the deeper background structure of our thinking. But actually, if we want to get rule of thumbs of what should positive obligations be, we've actually got a great example from Indian company law, where large companies must establish a corporate social responsibility committee, which develops a corporate social responsibility policy relating to a specific area where the company can make a contribution and monitoring. And the specific area broadly has to relate to fundamental rights. And there's an obligation on the company to spend at least 2% of its average net profits dedicated to these projects. And so in a way, this is meant to harness the power of corporations to advance important social goods. Okay, and I argue my model actually can help improve this by understanding the background structure. We can think more about how to utilize the specific functions, for instance, of corporations. We may think 2% of average net profit, that's profit, it's not turnover, is actually too low. There are various things that we can do to try and improve the model. But nevertheless, there's ways of simplifying positive obligations and ensuring corporate structure is understood to be a structure which contributes to the society overall. It's not just making money from that society. There's a shift in the very ethos of the nature of the corporation. Okay, next slide. So the multi-factorial approach, from what you've heard, it should be clear, and this is actually what happened in my thinking. I realized ultimately it requires the exercise of significant judgment in determining the content of corporate obligations. So I could have left it at the end of chapter 8, that's the model, but I wasn't satisfied about that, because if there's significant judgment to determine final obligations, how do we ensure that that judgment is exercised positively? And I'm ultimately interested in defending and ensuring fundamental rights are realized. And so thus I attend to the processes and structures that need to be put in place, perhaps not unusual for a constitutional lawyer to do that, but including reforming existing law and institutional structures to ensure that any judgments concerning corporate obligations are exercised in a diligent and justifiable manner. Okay, and the last part of the book addresses these questions. Chapter 9 focuses on the institutional structure and framework within which decisions are made by a corporation, and these are set by corporate law. And so I propose a whole set of corporate law reforms that are necessary, I argue, to embed fundamental rights in corporations and improve decision-making about their content, from who is on the board to what are their duties, to their accountability, to ensuring that there isn't too much deference shown by courts through a legal rule called the business judgment rule to corporate decisions. Chapter 10 focuses on the need to move beyond the national to the international, and looks at how can we improve decision-making surrounding corporate obligations, as well as how the international level can also help gain clarity on substantive obligations. And I can't show how most of the mechanisms at present are soft, and even there they need to consider the multi-factorial model. This is not just a model for courts, it's a model for decision makers, it's a model for legislators, okay? And also there's a need for more authoritative mechanisms, and I make various proposals about how those mechanisms should be developed at the international level, although at the moment I'm involved with the Business and Human Rights Treaty Initiative, and there's been on the table for a while, and there isn't a lot of political support in a way for stronger structures. But nevertheless, my role as an academic is to point out the gaps and is to say this is what should be happening, even if states are not willing to move towards what should happen. And eventually at some point, hopefully in a world that will be more friendly towards human beings and other sentient creatures, hopefully that will be something that is done. Okay, the next slide, please. And so in conclusion, I've given you a broad sense of the structure of the argument and some of the particular arguments. Corporations have always had significant impacts on fundamental rights since their proper development in the 19th century, yet they have often resisted recognition of their obligations, okay? They often like to claim rights, but they don't like recognition of their obligations. The time has come expressly to take their obligations seriously and to attend to two critical matters, I argue: developing their substantive content and ensuring decision makers are diligent in the judgments they make concerning them. I've focused on the analytical framework today, the multi-factorial approach, and how to determine the substantive content of the obligations. And that approach, I hope, will catalyze more discussion on this vital question and contribute towards strengthening the understanding of corporate obligations, both in constitutional and international law, and also therefore hopefully contribute to the advancement of the fundamental rights of individuals. Thank you very much.